presentation is about cases that related to women's rights. Okay, so the Craig versus Boren case was in 1976. Oklahoma established different drinking ages for males, which was 21, and females, which was 18. Curtis Craig, a boy between the ages of 18 and 21, and Carolyn Whitener, a licensed vendor, claimed the law was discriminatory. The conclusion was yes. The court found that, oh my God, the court found that the law was unconstitutional towards gender classifications. And so the part of the Constitution that this applies to is Amendment number 14, the Equal Protection Clause. You want some? Oh, just kidding, I'm sorry. I forgot that you're not 21, but I'm 18 and I can just chug it down.
So am I.
But you have to be 21 in order to drink alcohol. Nerd. Yeah, well, that's what the legislature said, so it's not my fault that I can enjoy this nice liquor.
I think it is your fault.
I don't think it is. I think this is all on you. You just need to be 21 faster. Nerds that can't drink, I hate them. I definitely just drink out of your water bottle. I'm so sorry.
Ew.
It was great though. See, I can enjoy her great liqueur, and you can't. It's definitely not fair, but like, I'm fine with it. That's a scene. So the Duren versus Missouri case took place in 1979. The Circuit Court of Jackson County convicted Billy Duren of first-degree murder and first-degree robbery. He claimed that the selection of his jury violated his 6th and 14th Amendment rights of a jury of his peers that was fair and representative. While women were 54% of the population, only 26% make up the selection of juries in Jackson County. So the question here is, does a jury that automatically exempts women from performing jury duty upon request violate a defendant's 6th and 14th Amendments? And that applies to their right of a fair and representative jury. Part of the Constitution that this applies to is Amendment 6 and 14. If the jury would silence. So the jury has spoken, and you are convicted of murder and armed robbery.
That's not fair.
And why is that?
Because my jury is only 2 girls and 15 guys.
Are you sure that was
I'm
wrong?
15 men.
Hey, screw you.
And that goes against my 6th and 14th Amendment rights to a jury that is representative of the population.
Wait, where do you see that?
Well, it's not there yet. But girls can like opt out if they want to be, if they don't want to be in jury duty, which is unfair to me because guys suck.
Will somebody fact check that for me? Because I can't find it in here.
To the Supreme Court.
I guess to the Supreme Court. So, the Griswold versus Connecticut case of 1965. Griswold was the executive head of the Planned Parenthood League of Connecticut. She and the medical director informed, instructed, and gave medical advice to married people concerned with birth control. Griswold and her friend both got convicted as criminals for assisting and counseling people interested in having sex with protection. So, parts of the Constitution that this would apply to is the Amendments 1, 3, 4, and 9. So me and my husband Gary are looking to take one step further in our loving relationship, and we want to have sex. So we want to do it as safely as possible. Can you tell us how?
Okay, well, there are a few options here. So I'm assuming you guys, by safe, you don't want to get pregnant. Okay. So a form of contraception is definitely needed to be sure that pregnancies don't happen. There's always birth control or condoms, both of which I think are probably affordable for both of you. A lot of people even choose to use both, so it's like 100% sure. Of course, nothing is 100% other than abstinence, but you know, this is the second best option. It greatly reduces the chances if you use both, so I highly recommend that. But if you just can afford one or just want to use one, that's also an option. You can look at this paper to get information and see what's right for you.
For us. Yeah. No, that's totally fine.
I'm the state of Connecticut. I don't like this. This is illegal. You guys are going to jail.
How dare he? The Gonzalez versus Carhart case happened in 2007. So, is the Partial Birth Abortion Ban Act of 2003 unconstitutional? So the decision that they made was the Supreme Court ruled that the abortion ban was not unconstitutional. Freaking frag! I say the word twice! Okay. The Supreme Court ruled that the abortion ban was not unconstitutional, even when not considering the safety of the mother during childbirth. The Partial Birth Abortion Ban Act of 2003. That was a U.S. law which banned the abortion of late-term pregnancies, which is typically second trimester. In all states, sentencing any physician who knowingly performed an abortion on a fetus, a human fetus, would be sent to jail if it was after the second trimester. So the impact on public policy was abortions past the second term are unjust, and performing them is punishable by jail time. So if that sucker is past the second trimester, can't get it out of you. Sorry. Okay. So me and my husband Gary, we didn't use any contraception or anything.
Obviously.
So we have a child, and I'm in my second trimester, right? And as much as I'd love to give birth to this precious baby, we can't afford to take care of a kid, and I'm afraid it's going to kill me during childbirth.
Okay, so there's options here. What are you thinking? Are you thinking an abortion?
Yes.
Okay, well here's the thing. You said your baby's at the second trimester?
Yes.
Okay, according to the Partial Birth Abortion Act of 2003, a late-term abortion is what this would be considered since this past the second trimester. That's illegal. We can't do that.
Oh.
So your only other option is to go ahead with the birth of the baby, but there's plenty of options after you give birth.
Okay.
You can give them up for adoption, something like that. You don't have to keep the child, but you can't afford it either.
Okay. All right. Thank you.
You're welcome.
I'm just gonna look like I'm scrolling.
I got you. Stop. Stop.
Yes. Thank you.
Hey.